And you can rest for a minute because I've got some things to say to my colleagues, but more importantly, so people around the country understand what's going on here. First of all, for your family and friends, I'm sure they're very proud and they ought to be. Uh, I think everybody recognizes your sharp intellect, a deep understanding of, and even great reverence for the Constitution. Your legal experience and public service are impressive. Your dedication to mentoring young students and women in the legal profession ought to be admired by everybody. In all respects, you're exceptionally qualified to be a justice. Many groups and individuals have written in strong support, so I guess now that the chairman's gone, I'm going to ask, as the next one ranking, I got some letters from 21 state lieutenant governors and from 20 secretaries of state that I want to put in the record at this point. Before I question, I have a few points to make. Yesterday, my Democrat colleagues spoke about their concern that you, Judge, wouldn't uphold certain laws, including the Affordable Care Act, and that you would strip Americans of their health care rights and those protections that come with it. These opponents said that Republicans just want to confirm you so that you, quote, will carry their policies forward, meaning Republican policies forward on the Supreme Court. But this only shows Democrats fundamentally misunderstand what judges are supposed to do. A judge is supposed to interpret laws in an impartial manner, consistent with the Constitution. Republicans aren't interested in seeing judges, quote unquote, carry their policies forward. Republicans want judges to interpret the law and the Constitution, not make law. We want judges that won't impose their policies and personal preferences in their decision making. Plain and simple. Policy making is not the proper role of the judicial branch. That role is reserved for legislative and executive branches. As the judge said, the political branches, elected by and accountable to the people, because you got a lifetime appointment. And if you do lawmaking, we can't vote you out of office. Lawmaking's our job. If people don't like what we do, they can vote us out of office. Some other points on the Affordable Care Act. The Democrats continue to misrepresent or claim to know Barrett's view on affordable care and access to health care. In fact, they made it their entire game plan yesterday, and I suppose today we'll see it again. But we should dispense with the total fiction the Democrats are peddling. Apparently, her technical concerns with Chief Justice Roberts' legal reasoning in the Obama decision disqualifies her. Democrats are painting the judge as heartless and on a mission to scrap the health care law. Frankly, that's absurd. Not only is Judge Barrett a mother of 7, she has children with pre-existing medical challenges of her own. No one on this committee or anyone has any right to suggest that she doesn't care about access to health care or protection for the vulnerable. Now, getting back to the technical concerns about Roberts' Affordable Care Act opinion, first, and I got 4 points along this line, her comments dealt with Roberts' statutory interpretation of just one provision of the law. That provision is no longer even in effect. In 2017, Congress zeroed out the so-called tax, the tax connected with the individual mandate. The question before the court this fall are entirely separate. She never ruled on the Affordable Care Act, nor commented on how she'd vote, meaning the judge, how she would vote. So it's pointless to speculate, but we're going to get a lot of speculation during this election season, just 2.5 weeks before the election. Now, second point, lawyers and legal academics often consider a court reasoning even when they have no disagreement with the outcome of the case. For instance, the New York Times recently reported Ginsburg, before joining the Supreme Court, quote, wasn't really fond of Roe v. Wade. She didn't like how it was structured, end of quote. I don't blame or don't know why Democrats have a different standard for you, Judge Barrett. Now, a third point. It's blatantly inconsistent for the left to use this line of attack. We all know that President Obama said that the ACA legislative mandate was not a tax. Even liberal Jeffrey Toobin said Roberts' argument was, quote, not a persuasive one, end of quote. So Judge Barrett's analysis of Roberts' legal reasoning is well inside the mainstream. Now, a fourth point, more inconsistency. The same Democrats vilify Judge Barrett as a threat to those with pre-existing conditions. Well, it seems that those same people just filibustered the COVID relief bill that would have protected pre-existing conditions. They're the ones that blocked the COVID relief legislation. Republicans stood ready to move forward with that bill and remain ready. Seems to me it's the other side who really playing politics with health care during a pandemic. The truth is, Judge Barrett already said, quote, a judge must apply the law as written, end of quote. She further commented, quote, to decide cases according to the rule of law, beginning to end of quote. That's what we should all look for judges to do. Now, for my first question. When Justice Scalia came to my office before his confirmation, and I think I brought this up with every nominee to the Supreme Court by Republican or Democrat nominees. I don't think I brought it up in my private conversation with you, but I always bring up, what's your attitude about legislative history? No, let me ask my question first. I'm sorry.
I thought that was it.
I think you probably know, Judge, how important it is. I want to know how important legislative history is to you. When is it appropriate to look to legislative history to interpret the statute? And are there some circumstances when more appropriate than other? And I'd like to also give your view on legislative history compared to what I heard from Scalia 35 years ago.
Sure. So I'm very comfortable talking about the use of legislative history because that's a matter of interpretive philosophy. What governs, of course, is the text of the statute. So, the legislative history can never supersede the text, and it should never substitute for the text of the statute. Justice Scalia, as was well known, railed against the use of legislative history, and I think it was because at the time that Justice Scalia went on to the D.C. Circuit, before he was on the Supreme Court, the use of legislative history had really kind of gotten out of control. And many courts, were saying things. Justice Scalia in his book quotes this line from a brief, the legislative history being unclear, we turn to that other reliable guide in statutory interpretation, the statute. And that has things backwards. And so I think Justice Scalia really tried to clean that up and say, listen, the priority is the text, and when the text answers the question, you don't go to legislative history. And there's some pragmatic reasons to be careful about doing so. Legislative history can be long. There's a famous quotation from Judge Leventhal that legislative history is like going to a cocktail party and picking out your friends. It can be easy to manipulate because there might be something in there for everyone. So as a general rule, I don't look to legislative history when I'm deciding cases. I wouldn't say that it would never be relevant. Even Justice Scalia himself said that there could be instances, for example, if you were trying to determine whether a term used in a statute, how it was used, if it had a technical meaning or how it was understood, that might be an appropriate time to consult legislative history. Or Justice Scalia himself consulted it when he was trying to determine whether there had been an error in the way the statute was drafted. He looked to legislative history to see whether what seemed unthinkable actually was unthinkable.
Now I'd like to go to a specific case. I'd like to go to United States versus Urarte, which involved the interpretation of Section 403 of the First Step Act, which you know I had a big part, along with Senator Lee and Senator Durbin, in getting that passed in 2018. This is the most significant criminal justice legislation in a generation. Our criminal justice system can't just punish and deter. It must also rehabilitate and promote successful reentry into society. The First Step Act accomplished these goals through prison and sentencing reform. It was well known that the goal of the First Step Act was to make smart and cost-effective changes to the criminal code and to reduce risk of recidivism. So I want to ask you about your dissent in this case. The issue was whether the sentencing reform provision of the First Step Act applied to a defendant whose sentence had been vacated. Here, the defendant had been convicted but not resentenced at the time of the First Step Act becoming law. The majority opinion cited the plain meaning of the First Step Act and congressional intent in finding that Section 403 would apply to a defendant with a vacated sentence. Your dissent, as I understand it, argued, among other things, that congressional intent shouldn't be heavily relied on since, quote, every statute requires a resolution of competing policy interests, end of quote. President Trump signed the First Step Act into law only 2 years ago, so wouldn't re-referencing congressional intent be accessible and relevant? And then another question, why did you find the majority relying on legislative history unpersuasive?
So we did. The majority, it was a very, very difficult case. It was voted on en banc by our full court. And the quote from my dissent that you're pointing to was actually that we had a dispute about what the plain text of the statute required. And so that portion of my dissent that you just read was saying that I thought that the majority had permitted the policy goals of the act to supersede the text. And in dissent, I argued that the text drew the line after someone had been sentenced. So if someone had already been sentenced on the date of the First Step Act's passage, and the relevant language was, you know, if a sentence had already been imposed, I thought with my dissenting colleagues, and this was consistent with the approach the Third Circuit had already taken, that that meant if the person had already been through sentencing. You know, in this case involved a resentencing. And resentencing can happen years after, and so it didn't seem to my dissenting colleagues and I that looking in the statute that the plain language of the text supported the majority's approach to it.
Now, I think on my next question on the same case, you may have just partially answered it, but let me go ahead with my lead-in and then also a question. Both the majority and your dissent in the case reviewed 403 of the Act under a plain reading of the text. As an author and leader in this law's passage, I'd like to discuss how a plain reading of the statute could lead to varying outcomes. The section in question contemplates when a sentence has been imposed on a defendant. According to the text of the statute and relevant case law, a defendant's sentence, if vacated, creates a clean slate. That means defendant is placed in the same position as if he had never been sentenced. But your dissent comes to the opposite conclusion on whether a sentence has been imposed. Note that I agree with you that the laws need to be read and interpreted literally. So my question is this: how could we come to different conclusions?
Well, that language, that it did not apply to defendants on whom sentences had already been imposed, my dissenting colleagues and I said, well, the language is sentences. It doesn't say, invalid sentences, and one could certainly say, if asked if someone had been sentenced, yes, he was sentenced, but that sentence was later vacated. And you're right that the majority relied heavily on this clean slate principle, but in my review of the law, this clean slate principle wasn't really present because, the Sentencing Reform Act, for example, instructs district courts applying the guidelines at sentencing to apply those that were in effect on the date of the original sentencing. So I thought that the clean slate principle, they were pushing a little too hard on it. And then, there's certainly unfairness. The First Step Act, its policy is clearly to bring justice to sentencing. But whenever you draw a line and who gets the benefit of a law, and this is especially acutely true in the sentencing area, it's very difficult. And, some people right on either side of the line will not get the benefit of the law wherever you draw it. So, for example, in this case, Mr. Uriarte had a co-defendant named Sparkman. His case came up right behind together. They had been tried together and initially sentenced together. But Uriarte's appeal took longer to resolve, or his resentencing took longer because of a lot of delays. So there was unfairness there, too, in the majority's approach, because Uriarte, despite the fact that he was more culpable than Sparkman, wound up with a sentence that was like 15 years less.
That's the end of my questioning on that, but let me make a comment before I go to my next question. My position has always been that legislative history can be instructive with respect to the intent of the statute, so judges should not completely disregard it. Certainly, I acknowledge that the legislative branch can be more careful about drafting laws, but I also think that judges should pay attention to congressional intent as set forth in history when there might be a dispute about how to interpret the statute. Justice Ginsburg, at her hearing, quote, and you've discussed this a little bit already, but I think it deserves emphasis because you're going to go through a lot of this business of maybe not being, and I know legitimately not being able to comment on a prospective case. So she said, quote, a judge sworn to decide impartiality can offer no forecast, no hints for what would show not only disregard for the specifics of this particular case, it would display disdain for the entire judicial process. Obviously, we all know, end of quote, we all know that that's the Ginsburg standard. The underlying reason for this rule is that making promises or giving hints on how a judge would rule in a case undermines the very independence of our system. But you're going to be asked about your personal views, as you just have been, on various topics, and how you might correctly decide. Of course, you know the judicial nominees should never promise their future votes on the bench in exchange for the president's nomination or a senator's support. You'd be showing the opposite of independence. So, my question. So I ask you, do you agree with the Ginsburg standard that it goes to the question of judicial branch's independence for legislative history? And all you got to do is say yes, because I've heard you talk about it.
Yes, I agree. The Ginsburg rule reinforces judicial independence.
Yeah. Now, here's something that a lot of people suspicion, so I want to ask you. Have you made any promises or guarantees to anyone about how you might rule on a case or issue that might come before you if you're confirmed to the Supreme Court?
I want to be very, very clear about this, Senator Grassley. The answer is no, and I submitted a questionnaire to this committee in which I said no, no one ever talked about any case with me, no one on the executive branch side of it. And that's one reason you asked that question, I think, as a committee, is that you want to know that no nominee has made any pre-commitments. Yeah. And so just as I didn't make any pre-commitments and was not asked to make any commitments on the executive branch side, I can't make any pre-commitments to this body either. It would be inconsistent with judicial independence.
Now, I know the answer to my last question, and Mr. Chairman, I'm going to reserve the rest of my time. The Democrats claim that you're being put on the Supreme Court so you can vote to repeal the Affordable Care Act. Is that your agenda? If confirmed, is your goal repealing the Affordable Care Act? Have you committed to the President or anyone else that you will vote to repeal the Affordable Care Act if confirmed by to the court?
Absolutely not. I was never asked, and if I had been, that would have been a short conversation.
I think that your record shows that you'll be a faithful judge that takes each case seriously and approach each case in an unbiased way rather than with the policy agenda in mind. Is it fair? We can reserve our time.
Absolutely.
Okay.
Senator Leahy,
Letters for the record.
I'll introduce the letters by Senator Feinstein will be introduced into the record without objection. Senator Leahy, are you with